Mr. Muller's case is 25M1510. Mr. Muller, good morning. Mr. Guard, good morning to you. Case comes on for continued arraignment. I think there's a pending motion.
Yes,
I remember. Let me start. I think I've read the defense position based on the motion. Okay. Let me just hear from Mr. Muller then. Mr. Muller, you understand the motion Mr. Guard filed?
Yes, sir.
What's your position on the motion?
There was another law firm that had called me telling me they wanted to take the case.
Okay.
They told me that I had to fire him before I hired them on.
Okay.
Then when I called them back and I had let them know that I had let him go, that they wanted $6,000 from me.
Yeah.
So now I don't have representation. So.
Well, you currently have representation. Mr. Guard is currently your attorney.
Uh-huh.
There was a motion filed asking to withdraw, to remove him from the case.
Uh-huh.
I haven't granted that motion yet.
Yeah.
I wanted to talk to everybody before we take that step.
Yeah.
So what is it that you want to do as far as representation goes? What do you want to do? You can just talk to me. Just tell me what you're thinking.
Well, honestly, I wanted to ask for recusal today or demand recusal on violations of oaths of office. But
So hold on, recusal, have me recused?
yes, sir.
Okay, well, let's talk about
but-
your representation first.
Okay. Yeah, I wanted a lawyer.
Okay,
That's moving forward. I wanted a lawyer, but
okay.
now I want to represent myself, sir.
Okay, I want to make sure I follow that. You had wanted a lawyer,
Yes.
applied for the public defender,
Yes,
you got
sir.
alternative defense counsel,
Now I'll just represent myself, sir.
looked into private counsel, probably going to be too expensive, likely.
Yes, sir. Yeah.
And you want to go forward and represent yourself.
Yes, sir.
You can do that. Of course, you know that. You have the right to do that.
Yes, sir.
And we're not set for a trial or anything yet. Are you hoping to set for trial as well today?
Yes, sir.
Okay. We're going to have to talk a little bit about that then. Before I do that, though, let me just check. Mr. Guard, I've read the motion. Any of the record you want to make? Mr. Mueller does not want to be represented by an attorney. All right. I'm going to release you. I'll grant the motion to withdraw based on Mr. Mueller's request. You are no longer his attorney. You're free to go. Or if you have another case, stick around. So, Mr. Mueller, now you, like you said before, predicted, you now are representing yourself, no attorney.
Awesome.
Okay.
Thank you.
Now, what do you want to do with your case? I heard you say set for trial.
Yes, sir. I mean, I would like to just throw it out, to be honest. I mean, this should have been thrown out at Deacon's Closet. It's a violation of a lot of rights, sir.
Can I just pause you on that?
Yeah.
I apologize. And I know you have some issues, legal issues you want to bring up. This is not the right moment to do that.
Yes, sir.
So that's why you want to go this direction. I want to just deal with the one issue right now, which is, do you want to set the case for trial today, or do you want some time to negotiate yourself with the district attorney? Or
Well, I haven't consented to any of this, sir. Everything I've done up to this point has been under duress and coercion.
so let me try it again a different way. Do you want to set for trial, or do you not want to set for trial?
I would not like to set for trial.
Okay.
I mean, I don't consent to any of this. So,
All right.
Before we even get into this courtroom circus, let me set the stage because what you're about to see is a masterclass in what happens when confidence shows up without competence. Today's defendant isn't just walking into court. He's strutting in with a backpack full of internet law, bookstore wisdom, and sovereign citizen energy. He believes rules are optional, authority is imaginary, and somehow, the judge is supposed to play along. Spoiler alert, that never ends well. This case starts simple, a trespass and obstructing charge, but quickly turns into something way more entertaining. You've got a calm, surgical judge. You've got a defendant who fires his own lawyer, demands recusal, claims duress, refuses consent, and still expects the system to magically work in his favor. And that's the beauty of court. Reality doesn't care what you feel. It cares what you file, what you argue, and what you prove. Watch closely because every sentence he speaks digs the hole deeper. From asking the judge to step aside, to rejecting a free win later on, to volunteering himself for trial like it's a spiritual retreat. This is one of those moments where ego starts driving the legal bus. And when ego drives, logic gets thrown out the window. So buckle up. Because this isn't just a court hearing, it's a slow-motion self-destruct with a judge calmly holding the remote.
What I'm going to do today then is I'm going to enter a not guilty plea on your behalf.
well, I haven't entered a plea, sir.
I know, I'm doing it on your behalf.
10-4. Or you don't use 10-4 here, sorry.
I understand it.
Yeah.
Speedy trial starts today, and that's preserving your right to a speedy trial. I'm now compelling, on your behalf, it's what your attorney would have done for you, compelling the prosecution to resolve this case within 6 months of today. That's preserving your right to a speedy trial. That deadline will be April 27, 2026. We're not setting it for a trial yet. You're not asking for a trial date, but we're now pushing the DA. Say, you got to take care of things. And if they don't resolve the case at a trial or through a plea bargain, case will be dismissed.
Yes, sir.
Okay? So we'll set it for a pretrial conference. How much time do you think is useful for you to figure out how you want to proceed with the case?
Well, I think me and the DA are going to have a conversation after this, so thank you.
Okay.
Yeah. We'll figure it out, and whatever date you deem.
Sure. So we can do 4 weeks from now. That gives you just under a month. Is that too much time or not enough?
I mean, I have to be here for another case anyway. I'm a witness in another case, so
Okay.
that's the 9th of December. So I'm good. I got to be here till the 9th of December anyway. So
I'll be in town, you mean?
I have to be in town for
Okay.
for that.
So let's do the 24th then of November.
Okay.
Let's do November 24. We'll set that at 9 a.m. It's an in-person appearance right here in Division 7. Between now and then, if you want to talk directly with the DA, make sure you have their contact information, email, phone number.
Got it right here.
Yep. And I know I've talked to you about this, but I just want to make sure, you don't have to talk to them. You don't have to.
I would rather reach an agreement, sir. It's gone on for way too long. I'd rather gracefully step out of the arena than I want to get back to the garden. I'm a healer, and I've been doing a lot of work in this town for the last 2 years, off and on. So I don't want to be in spaces that harden my heart. So
I got you.
I just want this to be done with and move forward with my life and heal myself and allow others to heal.
And I appreciate that spiritual position.
Yeah.
I'm speaking from a slightly different legal position. And I think you know this. I just want to say it out loud.
I can't negate who I am. So
I got you. I'm not asking you to.
Yeah.
That's the prosecutor. They're not your attorney. You don't have to admit any facts or say, I was there at Deacon's Closet or this happened, but this didn't happen. You don't have to do any of that because what you say can and will be used against you. That's the prosecutor.
Well, yeah, I already heard the plea deal from my previous attorney. So, as long as we can reach an agreement, as long as we can reach an agreement, that's fine. So,
okay.
Yeah.
If you can't reach an agreement,
yeah.
we'll talk about it in November. We'll talk just like this.
Cool.
Again, there's no surprises.
Yes, sir.
I'm going to talk to you however I need, to get the information to you. So if we don't reach an agreement, it's okay. There's other steps and we'll talk about them. Okay?
Thank you.
All right. Anything else, Mr. Mueller?
That's it.
All right. Thank you, sir. I appreciate it. Have a good day.
And here's where things quietly go off the rails. Mr. Mueller just fired his lawyer and decided on the spot to represent himself. That might sound empowering, but in court, that's like deciding to perform your own surgery after watching a YouTube tutorial. Yes, you're allowed to do it, but no one recommends it. Attorneys don't just speak for you, they protect you from saying things that can hurt your case. They control pacing, objections, strategy, and most importantly, exposure. Notice how the judge doesn't celebrate this choice. He carefully confirms it. That's because when someone goes pro se, the court has to make sure the defendant knowingly accepts the risk. And the risk is massive. The prosecutor is trained. The judge knows the law. The rules of evidence aren't flexible. Meanwhile, Mr. Mueller is operating on vibes, philosophy, and bookstore law. The scary part? He thinks self-representation gives him control. In reality, it removes his safety net. From this moment forward, every word he says belongs to the record. There's no attorney buffer. No filter. No cleanup crew. Just him, the law, and whatever damage he accidentally causes himself next.
Mr. Mueller's case 25M1510. Mr. Mueller's case comes on for a pretrial conference. Mr. Mueller here, pro se, without an attorney. Mr. Mueller, good morning, sir. Let me check in with the DA first. I'll come to you second, okay? DA?
Yes, Your Honor. I conveyed the offer, and he informed me that he would like to go to trial as a pro se individual.
Mr. Mueller, is all that correct?
Yes, sir.
Okay. I have a speedy trial date of April 27, 2026. Does that check with both parties?
Yes, Your Honor.
I'd like to get out of town sooner than that. Is there any
Oh,
way
no,
that-
that's not the trial date. I'm sorry, sir. That's the speedy trial deadline date.
Oh, okay.
6 months from the date we entered the not guilty plea
Okay.
last time. That's just the deadline by which this case has to be resolved.
Okay. Thank you.
I'm just making sure I
Gotcha.
wrote it down right. Everybody agree?
That's
Yes.
No, we're going to get the trial way sooner than that.
Okay.
That's way too far out. All right. And I don't know if you put it, no, I don't see it on my notes last time. Would you put the offer on the record?
Yes, Your
please?
Honor. The offer is to plead guilty to petty offense trespass and close with conviction.
Mr. Mealy, you understand that offer in the case?
Yes, sir.
Okay. And you understand this. I have to advise you of this. So I don't mean this to sound like anything other than me making sure you understand the decision you're making.
I'll let you talk.
Thank you. I've had people who took this the wrong way.
Yeah.
And I have to advise you. I have to make sure you understand if you go to trial,
Mhm.
as you're asking, and if you are convicted, I'm not saying you would be, but if you were convicted of the top count, class 2 misdemeanor, obstructing a peace officer, the worst case punishment you could face, and I'm not saying you would face this,
Yeah.
but the worst case you would face is up to 120 days in jail
Yes, sir.
on that conviction.
We've already talked about that. Yeah.
Yep. Versus the plea offer here, which would be a petty offense conviction and no additional sanction. You understand the difference between those two things?
Yes, sir. I'd just like to be heard. Yeah.
I got you.
Yeah.
No, I got you. That's fine. The only reason I had to do that is because there's been appellate cases where somebody's gone to trial, they were convicted, and then at the end, after the conviction, said, well, I didn't know
Yeah.
what I was facing. I didn't know that I was exposed to this worse sentence, and I would have taken the petty offense plea.
Yeah.
You're not in that camp. I know that.
Yeah. I would prefer to be heard over the 3 months. I'm more than willing to take the 3 months just in order to be heard, sir.
What do you mean through? 3
Yeah.
Oh,
yeah.
I'm sorry.
I'm willing to put that on the line is what I'm saying.
penalty.
Yeah.
3 months would be 90 days. 120 days is 4 months of
That's-
potential incarceration.
Still okay.
And again, I'm not saying you would face that. It's just the worst case.
Yes, sir. Thank you.
I got you.
This is classic sovereign citizen language creeping in. I don't consent, under duress, coercion, and the idea that if you verbally reject the system collapses. It doesn't. Court isn't a negotiation of belief, it's a process of jurisdiction and procedure. Consent is not required for criminal proceedings. If it were, no one would ever get prosecuted. The judge handles this perfectly. Calm, direct, almost educational. He explains that regardless of feelings, the court still has to protect the defendant's rights. That's why he enters a not guilty plea for him. Not as punishment, but as protection. It triggers speedy trial rules and forces the prosecution to move the case. Ironically, while Mr. Mueller thinks he's resisting power, the judge is actually helping him more than he realizes. Speedy trial limits the state. It stops delays. It creates leverage. This is something defense attorneys normally push for, and the judge does it anyway to preserve fairness. So while Mr. Mueller thinks he's being oppressed, the court is quietly doing him a favor he didn't even ask for.
So let's get some dates then with that April deadline, much sooner than that. When are you thinking of getting out of town, Mr. Mueller? You mean moving or just traveling?
I'm just traveling.
Okay.
So, I'm a nomadic. So,
How soon would you like the trial?
as soon as possible, really.
Okay. Do you want a motions hearing, a constitutional motions hearing or anything like that?
I don't know the difference between that. So constitutional, sorry, repeat that?
Yeah, sure. Do you have any motions you wanted to file in the case?
No.
Okay. You just prefer go right to trial?
Yeah.
Okay. I'm asking because if you wanted a motions hearing, I'd set a motions hearing, then a month later set a trial. If you want to do the trial, we'll try to get it as quickly as we can.
Just as quickly as we can. Yeah.
Okay. Yes, and you'd like a trial to a jury,
Yes,
not
yes.
to the court.
Yes. Yeah.
Jury trial. You got
Yeah.
it.
Thank you.
Can the people do the 16th of December? I got to tell you this. I've set quick trials. I've never set one this quick.
Cool. Yeah. Let's go. Yeah.
So the only issue with this is a couple issues. One, DA, you obviously have some police officers that you need to subpoena. So they say they're available, but they have to check with the witnesses I suspect that they'll have and make sure those witnesses are available, especially over that kind of holiday period of time.
Yeah.
If possible, they might tell me by the end of the week, Judge, that date actually doesn't work. We need a different date.
Okay.
So that's possible. So I don't want you to lock that in,
Okay.
in pen, put it in pencil. The
Yeah.
second issue that we have is I want to make sure, that you're good with that date, that you have everything you need to be ready for trial. And it's just a few weeks out.
Yes, sir.
We'll talk about that just a little separately.
Okay.
But for right now, you're good with the December 16 and or 17, because I set it over a 2-day period of time. Tuesday, Wednesday. Good for you?
Yeah, that's fine, sir.
Okay. Okay, here are the dates and times. You might want to write these down. You got a pen?
I'll just write it down on my phone.
Okay. So the trial will be December 16 and or 17. That's Tuesday, Wednesday. For right now, plan on 8 a.m. in person right here. Got it?
Thank you, sir.
Continuing, I'm going to set what's called a court's disposition deadline. That's a cutoff deadline. And I know you don't want to enter into a plea bargain, but I find it's useful just to have a deadline anyway.
Okay.
If you want to think about this, or if you wake up one day and you say, I think I'd rather just
Take the charge and
take
get out
the
of here.
petty, get out of here. Exactly.
Yeah.
I'll give you until December 8. That's a little over a week before the trial.
Thank you.
December 8.
Thank you.
That'd be the cutoff. You don't have to show up in court by that deadline. But
Understood.
if you want to make some plea bargain or you negotiate something better,
Okay.
all you have to do is either let me, the court, know directly, or let the DA know directly, and they'll file something and let me know, and we can vacate the trial so we don't bring jurors in.
Gotcha.
And we can resolve it on a different day. But I just want that decision must be made by the 8th, and I have to hear about it by that deadline.
Okay. Thank you.
Sure. Continuing. There's what's called a Rule 16 deadline. I'll set that for December 1, 1st of December. That's a week from today. And you have obligations on this day. The DA does too. December 1, both parties must file with the court, any witnesses you have that you intend to call, expected witnesses, including any expert witnesses. I don't suspect either side will have experts in the case. Let me just ask, DA, do you expect any experts in the case?
Give me 1 minute, Your Honor.
Sure. It's a alleged trespass obstructing.
Assuming no, but let me double check.
Okay.
No, Your Honor.
Okay. Mr. Muley, do you expect to endorse an expert or bring in an expert witness to talk about something?
Not that I know, but now that you've mentioned it, I probably should.
Maybe.
I'm gonna look into it now.
Now we transition from ideology to reality. First hearing ends and suddenly the tone shifts. The jokes stop. The stakes get real. Because what's coming next is the moment where logic should take over. But Pride doesn't like logic that he describes himself as a healer, someone who wants peace, growth, and spiritual resolution. Sounds great. But court isn't a meditation circle. It's consequences with paperwork. You can't manifest your way out of a misdemeanor. You negotiate, you calculate risk, and you protect your future. And that's why the next hearing matters. Because prosecutors don't offer deals out of kindness. They offer them to save time and secure convictions efficiently. When a defendant gets a generous offer, it's usually because the state knows the case is minor and wants it closed fast. So when you hear the offer in a second, listen carefully. Because what follows is one of the most painful courtroom choices you'll ever watch. Turning down a clean exit for the thrill of being heard.
Yeah.
But the deadline to do
16?
the deadline to do that will be the 1st. No, the
Oh.
trial is the 16th.
Yeah, okay.
First, you have one.
I'm sorry, I heard the rule of 16 and my brain.
That's Rule 16. That's the rule number.
Gotcha.
It's a standard deadline.
Yeah.
I'm setting that on December 1st. So 1 week from today, you must tell me,
If
file
I'm
with the
bringing
court.
any experts.
Not only that, but any witnesses you have. So
Okay.
any regular witnesses. I got a buddy who was there, who saw
Yeah.
everything happen.
Yeah.
If he or she's going to be here testifying, you must endorse that person, meaning write their name down, their contact information, and file that with the court. Experts are people who are not necessarily witnesses that saw something or heard something, but they could illuminate some more complicated topic
Yeah.
or subject for the jury.
Civil rights, yeah.
I wouldn't have a civil rights. It's not people to eliminate the rule of law. That's a different thing. That would be me. It would be a more of a factual thing. And that's why I said to the DA, I don't know that there's any factual issues that require an expert in the case. But if you could think of one,
Okay.
you're welcome to file one. I can tell you for sure there will not be any experts who educate the jury on areas of law.
Yeah.
That's not an appropriate use of an expert witness. Okay.
Okay.
But
Question. Sorry, then this may be.
it's okay.
But am I allowed to explain law to a jury?
No, what you can do is, a couple things. One, I will give the jury the rules of law that apply to this case. I will do that. I'll do that in writing. You have the ability to weigh in on what you believe the rules of law that they should be instructed on are. You get to help or at least provide input as to what the rules of law you think need to be highlighted to the jury are. And I'm going to get to that. I haven't even talked about that yet.
All right, I'll let you get through it.
I will instruct them on what the law is. Secondly, though, you may comment on those rules of law for sure during your closing arguments.
Okay.
In the case.
Okay.
For sure.
Okay. That makes sense.
All right. So that's the Rule 16 deadline. Witnesses provided to the court. Any expert witnesses, provide them to the court. Additionally, you have another obligation that's you must provide by next Monday, the 1st, what's called your defense, the nature of your defense, the nature of your defense. Now, listen carefully. That's not what the whole story of your defense or why you think you're not guilty, factually. It's just legally, what's the nature of your defense? For example, Judge, I'm not guilty because I wasn't me. They got the wrong ID, wrong person. Or, Judge, I'm not guilty because the DA can't prove the elements of this charge beyond a reasonable doubt. So maybe I was there, maybe I wasn't, but the DA can't prove the charge. That's what's called a general denial, not a specific denial. Or I'm not guilty, maybe not, doesn't apply in this case, but maybe I'm not guilty because self-defense. Yes, I did this. I hit somebody, but I did it defending myself, which means you're not guilty.
Yes, sir.
That when I say nature of defense, I mean just a phrase like that. General denial, self-defense.
That's also December 1st?
December 1st. You have 1 week to provide that to the court.
Can I just do that with the clerk's
Yep,
office?
you can file it right with the clerk's office. Yep. That's the Rule 16 deadline is next Monday for those witnesses, experts, and nature of defense.
Thank you.
Got it?
Appreciate you.
Let's pause right here because this is the most important decision of the entire case. The prosecution offers a petty offense trespass. No jail. No additional punishment. Case closed. Walk out. Go home. That's basically the legal equivalent of being handed the emergency exit door. But instead, Mr. Mueller says, I'd rather be heard. And that's where emotion replaces strategy. Court isn't therapy. Trial isn't a microphone. Jurors don't care about spiritual journeys. They care about facts, evidence, and instructions. The judge even warns him. Worst case scenario, he's facing up to 120 days in jail on the obstructing charge. That's 4 months of freedom on the line just so he can tell his story. And the judge isn't threatening, he's protecting the record so Mr. Mueller can't later say, I didn't understand the risk. And yet, despite all of that, he volunteers himself for trial. Not because the deal is bad, but because ego wants a stage. This is how cases flip from simple to dangerous.
Sure. Now, there's another thing we need to talk about. I'm going to issue, can you actually do it just in writing? Print it out? Correct. Oh, you've already got
On top of it.
read my mind. Most people get that electronically. I want you to get a physical copy so that you don't have to wait for it in the mail or something like that.
Okay.
So that's what's called a case management order or my trial management order.
Okay.
It lays out a lot of rules about just procedures on how to get through trials efficiently. And it's not just for you, it's for even attorneys as well.
Yeah.
There's a couple things I want to highlight in there. You'll read it, but I want to highlight it for you as well.
Okay, we can go over.
The Wednesday before trial. The Wednesday before trial. And that Wednesday is December 10. You must provide, and the DA as well, you must provide 3 things directly to the court. 1, what we call motions in limine. Motions in limine. A motion in limine is a motion regarding an evidentiary issue or some other issue that will affect how the trial goes. Not a constitutional motion or a motion to dismiss or something like that. It's just if you have a question or a concern about, say, evidence in the trial, Judge, the DA has body camera evidence, and I think there are clips on the body camera that shouldn't come in for one reason or another. Mm-hmm. That's a good topic for a motion in limine, meaning we could talk about it before the trial, so we're not arguing about how to edit a video during the middle of a trial.
Okay.
Something like that.
Okay.
If you have issues like that, or the DA, they must file that motion in limine by Wednesday before trial, noon, it says on there, so that I can review that and prepare a ruling on that, so we're ready to go for trial.
Okay.
So 3 things, motions in limine. The second thing is an updated witness list. So on Monday, if you remember the 1st, you're going to give me all the witnesses you have.
Mm-hmm.
Then the Wednesday before trial, you will tell me exactly the witnesses you are more likely intending to call. Sometimes people might say, I have these 5 witnesses, But then as you get closer to trial, you're like, you know what? I think I only need 3 of these witnesses. The DA does this all the time. They say, we have 5 witnesses, Judge. We figured out 2 of the police officers don't need to testify. We're just going to use 3 witnesses. That's what you need to tell me Wednesday before trial. Who are you really going to call? Because I just need to manage the timing of the trial. How many witnesses am I going to have?
Got it.
So just the updated good faith witness list is number 2. Motions in limine, updated good faith witness list. We're talking Wednesday before trial. The last thing is this. This is the law you were talking about. The parties will file jury instructions. That's the rules of law that you want me to instruct the jury on. You'll give me your proposed jury instructions. It works like this. In every case, again, with or without an attorney, the parties must confer, talk with each other, and together agree, if you're able, agree to a set of jury instructions. Typically, parties are able to agree to most of them. Not necessarily all, but most.
Yeah.
If you're able to do that, great. Then the DA will file one set of these stipulated, agreed to jury instructions. Now, importantly, there might be instructions that you want to give, or you want me to give to the jury that the DA disagrees with. And vice versa. They might say, I think this is appropriate, Mr. Mula, and you might say, I don't want the judge to read that to the jury. So if you have disputed ones you disagree on, each of you, after filing the stipulated set, each of you may file separately what I call disputed instructions. What you want to give, but the DA disagrees, what the DA wants me to give to the jury, but you disagree with. Tell me what that instruction is in writing, as well as any legal authority, why you think that's legally an appropriate instruction. Some legal authority supporting that. And usually there are a couple of those.
Okay.
Not many usually, but it's entirely up to you what you want me to.
I'll do my
what you want me
research.
to do. Yeah.
Thank you.
Sure.
Appreciate you.